Question 256. If a homestead exemption is recorded after a legal action has started, the exemption is A. Void, B. Valid, C. Unenforceable, D. Enforceable, if the legal claims is for less than $7,000. Correct answer is B. Valid. In California, the homestead exemption provides protection against after-recorded judgments, even if the exemption is recorded after a legal action has begun. This means that even if a lawsuit is already in progress, recording the homestead exemption can still protect the homeowner's equity from subsequent judgment liens. Question 257. Toward the end of a 30-year amortized loan, the payments are A. Mainly paying off the principal on the loan, B. Mainly paying off the interest on the loan, C. Composed of equal amounts of principal and interest, D. None of the above. Correct answer is A. Mainly paying off the principal on the loan. Amortized loans involve regular payments that cover both principal and interest. In the early years of the loan, a larger portion of each payment goes toward paying off the interest, and a smaller portion goes toward the principal. As the loan progresses, the balance of the loan decreases, and the proportion of each payment that goes toward principal increases. Toward the end of the loan, the majority of the payment is applied to the remaining principal. Question 258. Dave rents an apartment in a building owned by Sam that Sam has used for collateral for a loan taken out from Third Street Bank. When Sam defaults on the loan, the bank repossesses the building and evicts Dave. The remedies open to Dave include A. Suing the bank for damages, B. Suing Sam for damages, C. Not suing for damages because the bank properly repossessed the building for non-payment of the mortgage by Sam, D. Pursuing a criminal complaint against both the bank and Sam. Correct answer is B. Suing Sam for damages. Dave, as a tenant, has a right to quiet enjoyment of the leased premises. Sam, as the landlord, breached this implied covenant by failing to meet his mortgage obligations, resulting in the bank's repossession and Dave's eviction. Dave can sue Sam for damages resulting from the breach, such as moving expenses, lost deposits, and the difference between the rent he was paying and the rent he now has to pay. Question 259. The opposite of commingling of trust funds by a real estate licensee would be A. Losing trust funds, B. Investing trust funds, C. Segregating trust funds, D. Conveying trust funds to a trustor. Correct answer is C. Segregating trust funds. Commingling refers to the illegal act of mixing personal funds with client trust funds. Segregating means keeping client trust funds separate from personal funds, which is the proper and legal way to handle them. Question 260. Which is not an essential element for a deed to be valid? A. Grantor's signature, B. Competent grantor, C. Acknowledgement of the grantor's signature, D. B. In writing. Correct answer is C. Acknowledgement of the grantor's signature. For a deed to be valid and legally effective between the grantor, seller, and the grantee, buyer, it generally needs to include a competent grantor, someone legally capable of conveying property, a grantee, someone capable of receiving property, a written instrument, the deed itself, words of conveyance, a clear statement of intent to transfer ownership, an adequate description of the property, the grantor's signature, delivery and acceptance of the deed. Acknowledgement, notarization, is primarily required for recording a deed in the public records. While recording provides constructive notice and other benefits, it is not essential for the deed to be valid between the grantor and grantee. Therefore, a deed is valid without acknowledgement. Question 261. When co-owners of a property cannot agree how it should be rented out or sold, the legal proceeding that decides the dispute is called A. Partition action, B. Foreclosure, C. Mediation, D. Remainder suit. Correct answer is a partition action. Foreclosure is a legal process where a lender seizes and sells property to satisfy a debt. Mediation is a process where a neutral third party helps disputing parties reach a voluntary agreement. While it could be used before a partition action, it is not the legal proceeding that decides the dispute. A remainder is a future property interest. It's what someone gets after a life estate ends. A remainderman is the person who gets it. A remainder suit is legal action taken to protect the rights of the remainderman. A remainder suit relates to future interests in property, not disputes among current co-owners. A partition action is a legal proceeding where a court divides co-owned real property when the owners cannot agree on how to manage or sell it. This is the specific legal remedy for resolving disputes among co-owners. Question 262. The front-end ratio is calculated as the A. Monthly housing expenses divided by monthly gross income, expressed as a percentage. B. Monthly income necessary to meet future projected household expenses. C. Amount of money needed by someone to purchase the front end of a property. D. Both A and C. Correct answer is A. Monthly housing expenses divided by monthly gross income, expressed as a percentage. Front-end ratio, housing ratio, is a key metric used by lenders to assess a borrower's ability to afford housing expenses. It specifically measures the percentage of a borrower's gross monthly income that would go towards housing costs. These costs typically include mortgage principal and interest, property taxes, homeowners insurance, homeowners association, WA, fees, if applicable. Monthly gross income is annual income divided by 12 months. The ratio demonstrates what portion of an individual's income can be used to make mortgage payments. Lenders utilize the front-end ratio along with the back-end ratio to evaluate mortgage applications. Question 263. A party makes an offer to buy a property, which is accepted by the owner. Before the commencement of the escrow period, the fact comes out that the seller is a single minor. Therefore, the contract is A. Illegal, B. Voidable by the minor, C. Enforceable by the buyer, D. Valid, but the escrow period cannot commence until the minor reaches the age of 18. Correct answer is B. Voidable by the minor. Generally, minors, individuals below the legal age of majority, typically 18, lack the legal capacity to enter into binding contracts. Contracts entered into by minors are typically voidable at the minor's option. This means the minor can choose to disaffirm, cancel, the contract, but the other party cannot. The contract is voidable, meaning it's valid unless the minor chooses to cancel it. A minor can only void a contract during his minority status and only for a reasonable time after he reaches the age of majority. After a reasonable period of time, the contract is deemed to be ratified and cannot be voided. Waiting until the minor turns 18 does not automatically make the contract valid. The minor would have to choose to validate the contract. Question 264. If a prospective buyer asks the listing broker whether a previous resident of the property died of AIDS, the broker A. must truthfully answer the question, B. can decline to answer the question, C. refer the prospective buyer to another broker, D. both A and C. Correct answer is B. can decline to answer the question. California Civil Code Section 1710.2 specifically addresses this issue. It states that a real estate agent is not required to disclose that a previous occupant of the property was afflicted with, or died from, AIDS. This law protects the privacy of individuals and prevents discrimination based on health status. Disclosing such information would be a violation of privacy and could lead to discriminatory practices. Question 265. The main types of easement. A. Easement in gross. B. Easement in particular. C. Easement appurtenant. D. Both A and C. Correct answer is D. Both A and C. Easement in particular is not a standard legal term for easements. Easement appurtenant runs with the land, meaning it benefits a specific parcel of land, the dominant tenement, and burdens another parcel, the servient tenement. It's tied to the ownership of the land and transfers with the property when it's sold. For example, a property owner might have an easement appurtenant that grants them access to a private road in order to reach their landlocked property. Easement appurtenant benefits a person or entity, not a specific parcel of land. Examples include utility easements, like for power lines, or easements granted to a specific individual for recreational purposes. It does not necessarily transfer with the land.